Ladies and gentlemen, I believe there will be a unanimous decision to overturn the absurd ruling against Trump stating that he committed a federal crime in the hush money case. Hit subscribe to this channel right now. This is an article, Supreme Court, from CNN. Supreme Court unanimously rules to keep Trump on Colorado ballot. That was one of the many Supreme Court victories that Trump received. This one happened to be a unanimous victory. There was the presidential immunity victory that ties directly to Hope Hicks's testimony within the New York trial. But in addition to that, because Trump had the constitutional right to speak to his lawyer or longtime or staffer or advisor, Hicks being one of them, and not have that conversation be used against him in a court of law. But the main thing, and I've spoken about this the past couple of days, and hit subscribe to this channel, that's why the channel's doing so well, is because it will be overturned once the Supreme Court, it basically was already overturned. I'll explain, and I'll give you exactly the Roberts statements that have overturned the absurd guilty verdict. Okay, the hush money verdict in New York was predicated upon an imaginary federal statute. There doesn't exist a federal statute that Trump broke. The DOJ and the FEC dropped the case. A state cannot level a federal crime without the federal government involved. Here's John Yoo, and then we'll get to John Roberts in a second.
Grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
When we come back,
the Supreme Court will reverse when they get a chance, but they've essentially already reversed. When you look at the immunity and the Colorado decisions, overturning the Colorado ban and giving Trump presidential immunity, completely eviscerating Jack Smith's case, the special counsel, the quote-unquote special counsel's case against Trump. Hit subscribe to this channel, to my super chat. Thank you, Paul Bartlett. Thank you so very much. If you want to donate also via Patreon, ladies and gentlemen, and support the channel via Patreon, that's on my website, hagoodman.com. That will be below as well in the pinned comment. But Paul, thank you so very much, as always. This is John Roberts essentially explaining why the New York decision, the verdict against Trump, and the sentencing will be overturned.
The Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
So what Justice Roberts, you're going to hear the entire exchange, what he's saying is that state and federal government cannot accuse Trump of something he didn't do. Okay, that's number one. He did not commit a rebellion. You cannot interpret that he committed a rebellion if he hasn't been convicted of doing so. Colorado, for example, could not have done that. Tried to do that, and it didn't work out. It was a unanimous decision. I believe that the New York verdict will be unanimously overturned because Republicans can utilize that type of legal shenanigans against Democrats. They can interpret unilaterally federal statutes and then level that against Democrats in a state court. So if the DOJ dropped the case, the FEC dropped the case, he's protected under presidential immunity, there's no way it's legally valid, the conviction. these were misdemeanors, by the way, that had expired. The statute of limitations had already expired on these 34 misdemeanors, which, by the way, were 34 payments to Michael Cohen. We still don't know exactly for what. There was no evidence that showed that he paid to pay Stormy, but even if he paid Stormy, according to Bradley Smith, Hans A. von Spakovsky, and Trey Traynor, 3 Federal Election Commission chairmen, it wouldn't have been a crime. So this is 100% going to be overturned by the Supreme Court. But here, Justice Roberts is saying, well, you've accused Trump of everything under the sun. How do we know there's no politics here? And they're going to say, they say the same thing in New York. Look, there's politics involved. The DOJ dropped the case. What right does New York have to convict Trump on a federal statute that the Department of Justice didn't even think existed in the hush money case?
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said. But there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in the some cases. I'm not suggesting. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
The state of New York has not proven that his conversation with Hope Hicks or even his conversation with Michael Cohen weren't official acts. How do you differentiate an official and unofficial act? Oh, because Hope Hicks or some staffer or some legal advisor or Michael Cohen stated that the conversation was corrupt in nature? Where's the evidence? President Obama's former advisors can say that, well, you know what? He conspired to rebel against the country. I'll testify. Or Bush's former advisors can say, oh, he blatantly knew that the intelligence was false before sending Americans to never-ending counterinsurgency conflicts. So he's sending it back to the courts. The immunity case, he essentially provided immunity. The Supreme Court upheld presidential immunity, saying a speech is generally considered an official act. How do you make the absurd leap of logic that Trump's speech led to criminal activity? He didn't tell anyone to commit a crime. Similarly, how do you convict Trump in a state court utilizing evidence from Hope Hicks and Michael Cohen when they were speaking to a president in confidence? How on earth does that happen? Forget about the federalism issue that a state cannot level a federal crime without the Department of Justice involved.
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us. We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do. Prosecutors take an oath, the Attorney General takes an oath. So I don't want to overstate Your Honor's concern with potentially relying solely on good faith. But that's an ingredient, and then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
But what concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement, because the fact of prosecution was enough to take away any official immunity. The fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well,
Democrats are the very authoritarians they claim Trump to be. They are the Democratic Party, and state and local and federal prosecutors can be described by some as having been despotic, authoritarian, tyrannical when it comes to Trump. They did not explain what was an official and unofficial act, which is, of course, protected under the Constitution as presidential immunity. Or under presidential immunity. A president is allowed, for example, to perform a speech. Similarly, in the New York State Court, our system of federalism does not allow a state government to unilaterally, or state court, or anyone within state prosecutors to unilaterally define a federal crime. The federal government must level the indictment against an individual. Then the state government can level state indictments. But there was no federal indictment of Trump. Why? To the 1,000 plus people watching, everything I'm saying is 100% true. I think it's going to be unanimous, but if it's not unanimous, okay, forgive me. This will 100%, without a shadow of a doubt, certainty be overturned by the Supreme Court. And Democrats will yet again try to intimidate the court, and you'll hear Schumer in a second. The Washington Post has a headline, Roberts was admonishing J.D. Vance. He very likely, almost certainly, was doing that to Democrats. Schumer in particular. You'll hear Schumer in a second try to intimidate the entire court. Biden tried to intimidate the court. President Obama has. Democrats routinely, and media routinely try, look what they did to Samuel Alito and Justice Thomas. But they don't do any of that to the liberal justices. Okay? So, and Kavanaugh, there was a person who tried to end his life, just like there was a person who tried to end the life of Trump. And yet the conservatives in this country are the the belligerents. But the Democrats and the liberal Democrats, they're such good people. Anyway, let's continue. A state cannot level a federal crime. Also, a state cannot use the conversations that a president has that are privileged, private, classified conversations against him unless the federal government has stated, as well as the state government, that the president committed a crime.
I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There's certainly...
For official acts, Navy versus Egan, there's Supreme Court precedent that presidents are immune from civil, and now because Democrats tried to imprison Trump, from possible criminal conduct if their acts are deemed official. If, for example, the acts are deemed official and a federal prosecutor or state prosecutor try to make absurd leaps of logic the way Democrats did with the Jack Smith case.
There's no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow.
At minimum.
But Trump didn't need absolute criminal immunity because he didn't do anything wrong that day. He performed a speech. Then there's the viewpoint, well, he tried to use an archaic law to steal the outcome. He wasn't stealing anything. He tried to use the legal statutes that exist. It didn't work. End of story. Okay? He didn't believe he was treated fairly. Democrats actually bolstered his viewpoint, Trump, when 4 years later, less than 4 years later, they ousted a sitting president from his presidential campaign because of one debate with Trump, where he looked, it was abysmal. The entire thing was terrible, and it was exactly what every, Trump supporter has been saying for 4 years. How on earth did 81 million people choose a man that Democrats themselves kicked off and removed and kicked to the curb, and then replaced with somebody who polled lower, then losing the popular vote, every battleground state, Senate, House, presidency, and of course we know the Supreme Court was already lost for Democrats. Let's continue. Because of their own doing, because they don't even have primaries, and they cheated Bernie Sanders, who is a tool of the same system he claims to oppose. Anyway, let's continue. This is yet again John Woo, but I just want to play the longer part of the clip because he'll tell you, just like I will, it's essentially already reversed, overturned from what you just heard from John Roberts. But the Supreme Court, everyone knows the Supreme Court's going to overturn this. That's why they don't want to give Trump jail time, because they're hoping the Supreme Court doesn't look at it. But I think the Supreme Court will. You can't have the New York State Court hanging over Trump's head for 4 years.
The Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians that only because the Supreme Court has
really become a cancer on the political campaign system of the highest federal official in the United States and the election there too, no?
Mark, I appreciate what you said in your opening statement, because the Supreme Court has made clear, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
And they'll hear the case because he'll be sentenced. He won't be sentenced to jail, but it'll be a sentence saying, well, you're guilty of this, but you're not going to be sentenced to jail because you're president. But in the future, if perhaps I believe that the gag order is still there, there's a big problem. They can still go after Trump with that hanging over his presidency. Now, this is what Roberts, to the wonderful, respected, amazing people at the Washington Post, this is what Roberts was referring to, okay, in his recent review of the Supreme Court, his latest review.
I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions.
Imagine if Donald Trump, if you're a morally superior, highly educated liberal Democrat that thinks Trump tried to overthrow the country with a rebellion, meanwhile, like an entire summer of billions in property damage with a great many lives lost, countless confrontations with law enforcement that, of course, Cheney and others, Kinzinger and others don't care about, apparently. And if you're a morally superior liberal Democrat, you don't care about that either for some reason. And I agree with why people peacefully demonstrated, but it's like, you're going to ignore an entire summer and focus on one day because it suits you politically? Imagine if Trump said, you won't know what hit you. You've released a whirlwind, you won't know what hit. You'll pay a price. Imagine if Trump said you'll pay a price. It would be, oh my God, indict him. He's an authoritarian. He's a totalitarian. He's a despot. Trump, he's trying to go after his political rivals and cause a rebellion. But because a liberal Democrat said this, okay, that's what, and then Kavanaugh's life right after this, with the Dobbs decision, was someone almost took his life. Right after Schumer's statements. Where's his indictment? Oh, that's right. You only indict Trump for things that happen after he speaks. But this is Hans A. von Spakovsky, ladies and gentlemen, with all the problems from an FEC vantage point with the New York guilty verdict. Then we'll get to a very interesting analysis. Hope Hicks, that testimony can't even be used. So forget about the constitutional issues. They likely allowed testimony that is protected under presidential immunity.
I have the same reaction Francis Hicks does. This is a travesty, a miscarriage of justice. This was a phony prosecution from the very beginning. And for this jury, think about how many weeks this trial went on, how many witnesses came in, and in the very short time that the jury was out, they decided he was guilty on all 34 charges. This is a damage to the reputation of the American justice system like we have never seen.
Andres, thank you so very, very much. A quick recap, greatly appreciated. To my super chat, thank you. Paul, Andres, thank you so very, very much. This is really quickly. So there's already been a unanimous decision in the Supreme Court overturning the Colorado ban. I believe that John Roberts and every other Supreme Court justice, well, the conservatives at least, have already overturned the New York verdict with their statements on the overturning the Colorado ban and also the oral arguments on presidential immunity. They upheld presidential immunity, completely eviscerating Jack Smith's case. They overturned the Colorado ban unanimously because state and federal prosecutors, liberal Democrats, almost always, against Trump, made absurd leaps of logic. They made absurd leaps of logic. And what they did to Trump was unconstitutional in Colorado with the special counsel and now with the New York conviction. So from a constitutional vantage point, it will be overturned with 100% certainty. You heard, ladies and gentlemen, what Roberts has stated, has been saying regarding, you heard his rebuttals to the special counsel attorneys on immunity just now. They apply directly to the New York case. Okay? A state cannot level a federal crime without the Department of Justice and FEC involved. Now you're going to hear also Hope Hicks, that discussion, that testimony, they can't use that as evidence because it's very likely protected under presidential immunity. And that's what was used also as evidence to convict Trump. So from a constitutional vantage point, Trump can't be convicted and it has to be overturned. But also there's a presidential immunity issue. And all the problems that existed from an FEC vantage point, Trump didn't commit an FEC crime.
I have a colleague just got back from a conference overseas, and the reaction of lawyers and people there was that the United States has now gotten to be like the countries they are from, where the government uses its law enforcement powers to go after its political opponents. And that, I think, is exactly what happened here.
Hans, what was the underlying federal campaign violation? Did we ever find that out?
Well, you know, there was nothing in the original indictment about any kind of federal campaign violation. They kept saying that the legal expenses, which is what were listed in the business records, should have been a campaign-related expense, the payment that was made to Stormy Daniels. But as Brad Smith, I know, would have testified, under the test applied by the FEC, this was not a campaign-related expense, period. There's just no question about that. So for this jury to say that, oh yeah, he violated federal campaign finance laws and that justifies the underlying verdict, that is such an egregious mistake that the Court of Appeals in New York, when they get this case, they ought to reverse this almost immediately because of this and so many other mistakes made in the case.
Well, the Court of Appeals in New York, possibly like the court that convicted Trump, is influenced by politics. New York was run by liberal Democrats, Tammany Hall, for well over 100 years. And so this is not new. The Supreme Court, though, is completely independent. We know that because Democrats are up in arms always, unhappy with the Supreme Court preventing them, stopping them, blocking them from going after Trump. The only thing that has really kept this country from going into true authoritarianism is the Supreme Court. Democrats literally wanted to prevent Trump from running because they accused him of a crime he didn't commit. He didn't commit a rebellion. It wasn't a rebellion. It was a replay of an entire summer, but it happened to be in D.C. Okay? I still don't understand how Democrats can delineate between rampaging and property damage and chaos and mayhem on America's streets throughout the country and our nation's capital. Oh, so it's not an affront when a hard-working business owner, a person of color, anybody in America that owns a business, it's not an assault on democracy when that business is torched, but it is an assault only if it happens in a federal building? That's the way Democrats think, apparently.
How many do you count? How many mistakes?
I lost count of how many errors were made by this judge and by the prosecution. I mean, the judge let in all kinds of irrelevant evidence that had no bearing on the charges against the president, but were obviously there to blacken the character of Donald Trump. The judge shouldn't have even been on the case.
Here you have John Roberts refuting the arguments from Colorado. And Roberts' statements pertain directly to the New York verdict, which he will overturn 100% certainty when it gets to the Supreme Court.
Sort of look at Justice Thomas's questions sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges of immunity. They won't deprive people of property without due process. They won't deny equal protection. And on the other hand, it augmented federal power under Section 5. Congress has the power to enforce it. So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states, to enforce, implicitly authorized, to enforce the presidential election process?
Tear up your car insurance bill and try this instead.
Seems to be a position that is at war with the whole thrust of the 14th Amendment and very ahistorical.
No, Your Honor. First, we would locate the state's authority to run presidential elections not in the 14th Amendment.
So it's ahistorical because not only has it never been done, but it's blatantly unconstitutional. Okay? George, thank you so much. George, thank you so very, very much. This case, unanimous. I think that the New York verdict will be a unanimous decision to overturn it, even the liberal justices. If I'm wrong, at least I'll get, overall, it'll be overturned 100%. Definite. Once it gets to the Supreme Court, it'll be overturned. But you listen to Justice Roberts with the immunity and also now the Colorado, he's basically stating very clearly, there's no way the state verdict holds up from a constitutional vantage point. A state cannot level a federal crime. A state also, in Colorado, cannot unilaterally decide that Trump committed a rebellion. And the federal government can't accuse Trump of committing federal crimes when he's protected under presidential immunity, which also relates to the Hope Hicks testimony, which you'll hear about in a second.
Amendment, but in Article 2. And that power is nearly plenary to determine.
Yeah, but you're relying on, you have no reliance on Section 3, is that what you're saying?
No, Your Honor. Certainly we have reliance on Section 3 insofar as Article 2 gives states this broad power to determine how their electors are selected, and that broad power implies the narrower power to enforce federal constitutional qualifications.
Well, but the narrower power you're looking for is the power of disqualification, right? That is a very specific power in the 14th Amendment. And you're saying that was implicitly extended to the states under a clause that doesn't address that at all.
We would say that nothing in the 14th Amendment takes away from the states their broad and nearly plenary power to determine the manner of selecting their electors in the manner that they see fit. As this court said in Chiafalo, that power is nearly plenary unless something in the Constitution tells states they can't do it. And the structure of the 14th Amendment certainly was intended to expand federal power and certainly to restrict state power in some ways. But states are bound to enforce and apply, for example, Section 1 of the 14th Amendment. And so it's hard to see why states wouldn't be similarly bound or at least authorized.
That's not greater includes the lesser argument. The states have the power, the legislature has the power to choose electors, granted. But just because there's one authorized means in the Constitution to a particular end does not mean that there's any means to that end. And so I think you're taking that electors argument and bringing it into Section 3 where...
So, it's pretty clear cut. I just want to show you. So, Supreme Court unanimously rules to keep Trump on Colorado ballot. CNN, this is the Hope Hicks testimony. This could be inadmissible in a court of law because of presidential immunity. Hit subscribe, by the way, if you're new.
New York criminal trial. Former President Trump's top aide, Hope Hicks, is on the witness stand. Hicks served in the Trump administration as White House communications director and later as an advisor. Now, she is the 9th witness called by the prosecution. We are also awaiting a ruling on 4 more Trump gag order violations. Both sides argued on the matter yesterday, but Judge Merchan is yet to make a decision. Hello, everyone. This is Outnumbered. I'm Emily Campagno here with my co-hosts Harris Faulkner and Kayleigh McEnany. And also joining us today, co-anchor of America Reports, Sandra Smith, and Fox and Friends Weekend co-host and author of the upcoming book, The War on Warriors, Pete Hegseth. First, let's go live to Eric Shawn, who is outside the New York State Supreme Court with more. Eric.
So the entire testimony from Hope Hicks could be inadmissible because it was a private, likely classified conversation with a president. So she was, I mean, this is the presidential immunity ruling reinforced that Trump cannot be convicted when he's engaged in an official act. An official act is speaking to an attorney, an advisor, a staffer. You can't simply just take those moments in time and then utilize them in the court of law because of what essentially is gossip and hearsay.
Yeah, Emily, she was at his side during the election campaign and in the White House. Now, former close aide Hope Hicks to former President Trump is looking at him directly.
George, if your assumptions are true, why must Trump go to New York City? I agree with you on that. But I think that he is. I think that if he doesn't, if the judge in the case forces him to go and he doesn't go, there could be, legal repercussions. Then the judge could say, well, you know what? You're going to jail. So that's, I think that if there's any jail time or prison time, then 1,000% the next day or week, it's the Supreme Court will hear it. I think that they've already been working for the Supreme Court to overturn any sentencing, even sentencing that conditional sentencing or sentencing that doesn't lead to prison time. Okay, the reason that they don't want to the reason they can't sentence Trump, the reason they can't sentence Trump to prison is because, number one, so unconditional discharge, that's the term. They sentence him to an unconditional discharge, which is no jail time. But the reason they can't sentence him to prison time is because he didn't commit a crime. He didn't commit a federal crime. The FEC and the DOJ dropped the case. It's blatantly unconstitutional. The Supreme Court would overturn it immediately if he was sentenced to prison. But I think that they're trying their best to get it to the Supreme Court, and it would be unanimously overturned. Thank you, George.
From the witness stand, Ms. Hicks, as we speak at this moment, is testifying in this trial here at Manhattan Criminal Court. She, of course, the longtime loyal member of Trump's inner circle, his 2016 campaign press secretary and later counselor to the president. She is testifying about what she may know concerning payments to keep the stories of Trump's alleged affairs quiet. In his testimony, National Enquirer publisher David Pecker said that it was Ms. Hicks who was in and out of that meeting at Trump Tower in 2015, where Pecker, Trump, and Michael Cohen hatched the plan for Pecker to be campaign's eyes and ears to keep a lookout for any potential scandals that could tarnish Trump. And Pecker also testified that he did have a phone call with Hicks and former White House press secretary Sarah Huckabee Sanders at one point after Karen McDougal went public with her claims that she had had an affair with the former president. That phone call happening in 2018. Hicks will likely be asked if those...
So that could be protected under presidential immunity. I mean, I can't tell you if, that or other conversations that Hicks talked about, like which ones are protected, which ones aren't, but that's the problem. The state court hasn't even made reference to that, and the Supreme Court has already ruled that Trump is protected under presidential immunity for official acts. An official act is speaking to Hope Hicks about whatever he wants to speak about. Then you say, well, it was within they were committing he was committing a crime. It's like, no, he wasn't. The FEC dropped the case. Where's the federal crime? But even if you want to say he was in the process of at the moment committing a crime, you still haven't explained how presidential immunity isn't a part of the equation.
Those efforts were made to protect the president's reputation, as the defense claims, or as the prosecution charges, to hide those claims from Karen McDougal and Stormy Daniels to protect the Trump election. As her former boss looked on, Hicks admitted this morning when she took the stand that, quote, "I'm really nervous." She stopped at one point during her testimony to say this will get some getting used to, and she appeared to be at unease. She is detailing her role with the campaign in the White House, saying she was in key meetings, and she just a few moments ago was asked about Michael Cohen, but there's no major development about that. She also testified that she used to speak with and see the former president every single day, but has not spoken with him since about a year and a half ago. She also is testifying here, not voluntarily, but under subpoena. Back to you in the studio.
So if she is testifying on meetings she had with a sitting president, that's protected under presidential immunity. Okay? The federal government has not accused Trump of a crime. So you can't say that, well, he was in the process of committing a crime. But the federal government dropped the case. So the state government now can decide what is a federal crime? I don't think so. So these meetings that she's had as a top staffer are almost certainly covered under presidential immunity, especially since the DOJ dropped the case. If the DOJ hadn't dropped the case, maybe there would be a rebuttal to it, but the DOJ and the FEC dropped the case. So how on earth can the presidential immunity ruling not apply to the Hope Hicks testimony?
Eric, Sean, thank you so much. All right, let's bring it back to the couch. Pete Hegseth, break down yet again on the ninth witness the next and latest development of this sham trial.
Well, even other networks are willing to openly say there's precious little evidence here. I mean, to begin with, the charges aren't predicated on anything serious, and the evidence that Alvin Bragg's trying to develop isn't there. I mean, take yesterday, for example. So you've got Stormy Daniels' lawyer is on the stand. He refuses to say that it was hush money. He refuses to say that it was a payoff. Instead, he says it was consideration. You know what that's code for in the legal world? Extortion. And that's what this guy does for a living as a lawyer, finds clients who have been involved with or alleged to be involved with high-profile clients, and they fight for money for consideration to protect their reputation, right? That's effectively what he's talking about. By the way, he's the same lawyer who helped draft a statement from Stormy Daniels that denied all of it. So he's also on the stand trying to keep his law license because the letter that he signed was from Stormy Daniels saying nothing happened. And so he's contorting himself, trying to bend and say, well, it wasn't romantic. Maybe it was it was all a mess. And then you've got also on Cohen, he acknowledged, Stormy Daniels' lawyer, that Cohen was suicidal wanted to kill himself potentially because he didn't have a job in the Trump administration. Well, that gives plenty of motive for Michael Cohen to not be truthful. He's angry. And so he's angry about it. And why would he not mischaracterize it? They don't have good evidence here.
And Sandra, as Pete has.
So Pete Hegseth got an early, glimpse into very sordid attempts by Democrats and media to just tarnish the reputation of an individual. So it's like, it's really interesting listening to his analysis. Democrats look at this and say, well, any report, any allegation against a Republican or Trump must be true. They look at it as if it's gospel. Any allegation against them, against Joe Biden right before during his campaign the first time to run for president 4 years ago, where a woman accused, was not believed by media and by liberal Democrats. In fact, there were essentially hit pieces written against her. There was one article in one publication where they interviewed 100 of this woman's colleagues and friends and family. Can you imagine if they interviewed 100, if they did the same type of things to a person alleging something against Trump? They went after that human being with a fine-tooth comb to try to disparage her because they had to protect almost certainly a Democratic candidate 4 years ago. And then they made, very, very condescending leaps of logic. Oh, something to the effect of like, oh yeah, it was a tumultuous life. What right do you have to say that someone's life was tumultuous simply because they accuse a Democrat of something unspeakable and not only criminal, but diabolical? So Biden was accused, but Democrats didn't care. because they only care if a Republican or Trump is accused. Then it's gospel. Any accusation against them is hearsay.
Has laid out, there are so many questions just by us watching.
And if you care about Pete Hegseth and you're the Democrat here, there was a police report filed by the person who leveled the accusation against Biden.
Can you imagine the questions the jury has as this is playing out before them?
Yeah, and Hope Hicks, great to be here, by the way. Hope Hicks has, I think, a stronger reputation in the mind of many Americans. They recognize her. This is
Nicholas, thank you so very, very much. Thank you, Nicholas. Thanks, everybody. Thank you, Nicholas, as always.
a familiar name to so many. She was the press secretary during the 2016 campaign. She was then communications director inside of the Trump White House. We saw her comings and goings. We know she was very close to the former president during those days in office. And it was reported heading into this that she has not spoken to the former president since 2022. She has since said that on the stand in just the last few moments. Obviously, the effort here is to try to reveal anything she knows about those discussions, conversations that took place. A big goal might be surrounding the Access Hollywood tape and the release of that, and any efforts to obviously buy the silence of Stormy Daniels. So this is going to be an interesting one to watch. I think this is people are going to stop and listen to see what comes from this. But it's going to be about the relationships and the discussions inside of that White House. And she's going to have.
If it's about relationships and discussions inside of the White House as Trump was president, these are protected under presidential immunity, especially since the federal government didn't charge Trump with any crime. And the state government is assuming that it has the right to unilaterally decide what the federal crime was. So, I mean, this is so convoluted, and it's so easy to understand, yet it's so convoluted because they've contorted themselves into such a pretzel to try to get Trump.
Have a lot of information to share on that, so we'll see where they go with it.
And Kaylee, let's talk about silence for a second and how it pertains to President Trump. Now, the judge has come out and said, well, you can testify here. You can testify in court, but the reality is, as we navigate these gag orders, that the president can't campaign effectively. He maintains, and especially in the court of public opinion, when he can't even address or respond to the bevy of attacks coming his way, while other witnesses and other participants get to enjoy Netflix documentaries and TikTok and all the like. Yeah.
And that's the primary reason that even if there's no prison time, jail time, they're going to want to get this to the Supreme Court as soon as possible. And the Supreme Court will issue a huge victory for Trump. But see, again, they're pretending that that Roberts went after J.D. Vance. The Supreme Court is intimidated. The 6 justices, they're not intimidated, but there's been a concerted effort to intimidate them by Democrats. The political side intimidating the Supreme Court that wants to pack the court, that is constantly going after the Supreme Court, is the Democratic Party, not Trump. Trump keeps winning Supreme Court cases, okay? But the unconditional discharge, that will be overturned. Everything will be overturned once it gets to the Supreme Court. Hit subscribe to this channel, people. Thank you so very, very much. I will be back tomorrow. Hit subscribe. We're almost at 171,000 subs. And we're 271,000. We're on our way to 300,000 people. It's because of you. And I just thank you, Nicholas, Paul, Bartlett. I cannot thank you enough, Paul and Nicholas and everybody here. George, Andres, thank you so very much, everybody. And I'll see you tomorrow, everybody. God bless you all. Have a great, great evening.